case on this morning's docket. That is case number 109374, State of Kansas v. Domingo Alfredo Soto.
Good morning. Mr. Soto appears through counsel Michelle Davis, and may I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you. This is a case where the state's theory of the case was that a gentleman by the name of Lane and another man went to Mr. Soto's residence, and that Lane had obtained a gun from Mr. Soto, and then Lane and the victim left the property and were out in the country, and that Lane then shot the victim, and that Lane's motive for this crime was that Lane and the victim had been involved in some prior criminal activity, and that Lane was concerned that the victim was going to incriminate him to the police. And so the state prosecuted Mr. Soto under a theory that he had aided and abetted Lane in the killing based upon the fact that he had provided the gun to Lane. And Mr. Soto's defense here was what trial counsel called a state of mind defense. Mr. Soto acknowledged that he had provided the gun to Lane, but Mr. Soto disputed that he had done so with the required state of mind, which is a premeditated intent to kill, to facilitate a killing. And so on that basis, the case proceeded to trial. Most of the evidence was about Lane said this, or several witnesses that were testified that said Lane told me this, or Lane said this. These were not law enforcement witnesses. These were just regular witnesses. And prior to the trial, a couple weeks prior to the trial, the state had moved to admit this hearsay evidence. And the state had told the court that Lane would not be available to testify because Lane, of course, was charged with the killing and that he was going to invoke his Fifth Amendment right and he wouldn't be available as a witness. And so the state found that the hearsay statements met a statutory exception, and the state allowed the hearsay to come in. The main issue in our brief is that following the trial, the defense moved for a new trial. And the defense moved for a new trial on the basis that apparently on the second day of Mr. Soto's trial, during the lunch recess, the state and Mr. Lane had reached a plea agreement. And Mr. Lane had agreed to plead to a reduced charge. And the basis of the motion for new trial is that the state should have disclosed that information to Mr. Soto's attorney.
What good would that have done?
Well, the way that trial counsel presented in the motion for new trial is to say that basically is that the defense could have called Lane to testify.
But I guess the question would be when.
Right, and there's two, I mean, the way this was presented to the court, because this was not a mistrial request, this was a new trial request, defense counsel was saying, sort of in the interest of justice, you should grant us a new trial because Lane's available to testify.
No, but the point is, I think, what Judge Malone's asking, he's not available to testify, or at least he can invoke his right not to testify. He's not available. Is he until after his sentencing and then the time to assert an appeal is run? So, and I think that was some 50 days after the plea.
Right, and the way trial counsel presented this is to sort of say...
So is your suggestion is that we just stop the trial for 50 days until Lane's available?
Well, I think what the trial counsel suggested to the district court is that we could have stopped our trial. We could have waited.
50 days.
That's what trial counsel suggested. He said something along the line of Lane would have been available in approximately 4 to 6 weeks. I guess contemplating the time it would have taken to do a plea and then get sentenced. And at that point, Lane could come in and testify. And the way that trial counsel characterized this is that basically, given the circumstances of this case, that Lane was such an important witness, that they were trying Mr. Soto based on the fact that he had aided and abetted this man, and that therefore Lane's testimony was just so crucial because it wasn't proffered what Lane's evidence would have been, but it was argued that Lane was crucial to Mr. Soto's defense.
Why don't you need a proffer?
Well, a proffer would have been helpful.
Because
I agree.
it seems
Yeah.
to me that with respect to the conversations between Lane and Soto before the fact, he could have killed your client's case, that he could have been more harmful than helpful, and I don't see a lot in the record that would indicate how he would have saved the day for your client.
Yeah, and the other thing I think that's difficult is that it's apparently Lane kept giving different versions of events to the police. And so I think part of what trial counsel's imagining here is that it's one thing, when Lane's being accused of this, there's a tendency maybe to minimize and to point the finger at somebody else, and that perhaps after having taken the plea deal and being sentenced, that Lane would be a more favorable witness to Mr. Soto. That what he told the police that one night is one thing, but he would be a good witness for the defense after the fact. So I think that's what trial counsel here was trying to argue.
Ms. Davis, just
Yes.
one other point on that. Because of the lack of a proffer, there's an assumption here that Lane, once all the legal requirements are gone, that he would have wanted to testify. And there's really no indication that he would have testified, even if he was available to testify, is there?
Well, no. I mean, it's assuming though he wouldn't have had the privilege anymore.
Right, but
So,
he had just been sentenced to what?
yeah.
15, 20,
Right.
20
he
years
could
in
have-
prison?
He could have refused to testify, that's true.
I mean, contempt wouldn't really do much good there, would it?
Right, he had no incentive, that's true. So I think I've covered that issue
I have
fairly
another
well.
question related to it. The hearsay exception employed here was admission against interest, right?
Yes, Lane was making statements that were against his interest because he told a third party that he had to shoot this person or something along that line.
And does that exception require unavailability of the
No,
defendant?
but I think this goes, and that's partly what's difficult, is that in the denying the motion for new trial, the district court stood by its hearsay ruling. But there's more to what the defense was saying than hearsay. And the defense it wasn't just that his statements were going to come in through somebody else. It was that he was actually going to be able to be a witness. And plus,
Confrontation.
yes, plus.
But is there a right to confrontation in a situation where the statements are non-testimonial?
Right. So the hearsay, there's more to
I'm
it.
sorry, is there or is
No,
there?
there isn't.
Yeah, I didn't think so.
There-
So
there isn't,
confrontation
but-
didn't work for you here.
Well, it would in terms of you would have been able to bring in what Lane had told the police. And the state claims that the defense could have done that anyway. But it's, again, it goes to more than just this is what he said that night. It's that he could be a witness for us. So it's more, this would have been part of our defense. Not just that we could have brought in his statements that were made to the non-law enforcement, which would be hearsay, then our statements made to law enforcement, which would be confrontation, and then the third part would be defense. So there was more to this ruling,
And that's why we're stymied because of lack of a proffer.
right?
Okay, thank you.
Counsel, before you proceed, this was we're here today on a denial of a motion for new trial,
Yes.
correct?
Yes,
And our standard of review of the district court's decision is for abuse of discretion?
yes, that's true.
And what particular subset of an abuse of discretion are you relying on?
I would also note, though, that if there's a constitutional claim or constitutional violation, that the discretion is limited. There would be two parts to that. One would be that it was unreasonable. And the second part would be based on error of law. And my only argument on that is that the district court never really ruled about the underlying constitutional claim. The district court simply said, I'm going to stand by my hearsay ruling. And so the error of law would be that he never addressed the constitutional claims that were being made in the motion.
And that leads us back then to please specify what those constitutional claims are when we have a hearsay exception that doesn't involve the right to confrontation.
Well, the motion for new trial was based more than just the hearsay. It was more of a due process fair trial, as the state should have disclosed this information to us during the trial, that we could have done something with it. And then the second was that perhaps we could have used Lane in our defense. So again, it goes more to fair trial and due process, I think.
And are you finished with your questions?
Yes.
To summarize what I think you told us earlier, you admitted, I think, to Judge Malone that, was his name Mr. Lane?
Yes.
Could have refused to testify.
He could have, yes.
And if he had not refused to testify, we still are not clear whether he would have helped your client or hurt your client with his testimony. Is that right?
Yes. Based on the record we have, that's true.
And in terms of, I'm sorry.
And I was just going to say, I'm struggling with how there is error here that would justify a new trial based on the concessions you've made so far.
Well, I would just have to go back to trial counsel's argument below, which is given the circumstances of this case, since Mr. Soto is being charged as an aider and abetter, and the one witness who basically his testimony is being used to convict Mr. Soto was not able to testify or could not testify at the trial, and that given the circumstances of this case, and the underlying on a motion for new trial is in the interest of justice, that Mr. Soto should receive a new trial so that this very important witness can testify or be available to testify.
Okay. Justice Luker, you had a question?
Well, so in essence, are we looking at the reasonableness of a refusal to continue the trial?
Well, no, because you can't go back because the defense didn't know. So the argument here, I think, is that it was unreasonable for the state not to disclose this information, given the circumstances of this case, given how crucial this witness was. Because, I mean, nobody had the information. Apparently this didn't come out until after the trial.
Even as of the time of the motion for new trial, what's the sequence of events here? Was the motion for new trial heard before Mr. Lane had formally entered his plea? So we still at that point, when the trial court was ruling on the motion for new trial, didn't know if the plea would actually be entered.
Yeah, I believe that's correct. I'm not 100%, but I believe that's right. Because I think there was 2 months after the trial that he entered the plea, but I'm not sure. But I think the state didn't dispute that there had been an agreement and that Mr. Lane had, I mean, I don't think that's in dispute. He was going to play. So I'd like to, oh my gosh, I'm running out of time. I want to quickly, if I could, maybe I could get back a little bit of my rebuttal time, Judge. I wanted to mention issue 2 a little bit.
We've been using up a lot of your time with our questions, so you proceed.
Okay, thank you. I just want to briefly mention on the second issue about the failure to give the lesser. And what I want to talk about is the state claims that this was invited error. We submitted that it was a clearly erroneous standard. The clearly erroneous standard is it's not requested or objected to. And in this case, at the instructions conference, the court asked counsel, do you believe there are any facts that would justify a lesser included? And counsel said no. And it's our argument that that's counsel saying this is why we're not requesting the instruction, because we don't believe there are any facts to support it. The state is arguing that that's invited error based on Angelo. And in Angelo in 2008, this court said, where trial counsel said, Judge, we affirmatively do not want you to give this instruction. We are doing an all or nothing strategy here. That there's a difference, and the state quotes a court of appeals case where the instruction was, the court asked, do you want the instruction? And the trial counsel declined it to say, and the court of appeals said that's invited error. So I think clearly erroneous and invited error are getting, there's no distinction. They're getting kind of blended together. And I think there needs to be a difference between not requested and affirmatively saying, we don't want you to give the instruction.
But let me understand here, the counsel, defense counsel who presented the case, his defense, and sat through trial, the state who prosecuted the case, and the judge who presided over the case, all agree that there's not facts to support the inclusion of a lesser.
Yes.
So what's your argument that there are?
Well, the difference is, I think.
I mean, can you point to facts that there are?
Right, and
I guess that's my
you can
question.
reach the merits of the claim. My whole argument to you is reach the merits. With
Okay.
invited error, the state's saying, don't even reach this.
All right, so you're...
This is the state saying, you don't even have to consider this claim because it's invited error. That's a problem. And now, anytime a defense attorney says, no, we're not requesting it, the court of appeals, that's invited error.
So let's assume we reach it. Now, can we answer Justice Rose's
Well,
question?
I would just rely on my brief for that because it's a very brief argument. It's basically what the jury could have found for the lesser. But
No, that's not clearly erroneous.
Yeah, and it may
The
not.
could isn't, it's would
Right,
on clearly erroneous, not whether they could have.
right. And it may not be clearly erroneous, but that's the appropriate standard to apply. And I think that just needs to be clarified. That would conclude my comments unless there are questions.
Any more questions? Thank you, counsel.
Police Court, Gary Disney for the State Assistant Riley County Attorney. I want to make sure before I start that it's put in perspective what happened on that second day of trial. It's a noon break. The defense attorney for Lane says, will you agree to this number? And I say, yes, I'll agree to that number. And she leaves the courtroom. I don't know if Lane's going to agree. I mean, they phrase it that an agreement had been reached. The attorneys had agreed on a number, but there was no agreement with Lane. I mean, I'm assuming he would take it, but when he left the court, he certainly I hadn't been told he was going to take it. And he could have, attorneys back out of plea agreements all the time. So I don't want to, I want to make sure everyone understands that there wasn't a signed plea agreement reached. So,
And neither the state nor the defense in this trial had attempted to subpoena Lane. Is that correct?
That's correct. And I think in the transcripts, when we argued for the declaration against interest, I had called the defense attorney for Lane and said, if I subpoenaed him, would he testify? And she said, no, he would not. And when we brought that up, when we argued the admissibility of the declaration against interest, we told the court, Lane's not available. His attorney says he's not available. And we only did that to explain to the court why we're going to have this hearing on the declaration against interest. And counsel in the brief repeatedly says that the state said that Lane was unavailable. We only did that to tell the court this is why we need to have a hearing. This is why we're not calling him. But
Well, Lane's counsel came in and said he wouldn't allow him to go to testify, didn't he?
well, I proffered to the court. I had called counsel.
Okay, that was a proper. Okay, thank you.
But the point being, unavailability had nothing to do with the declaration against interest statements coming in, and I think the defense brief kind of tries to make it look like we were snookering him by saying he's unavailable when really we had this agreement that he was then going to become available. But unavailability had nothing to do with it.
Was the plea discussions involve any kind of cooperation with Mr. Lane with the state's case against Mr. Soto at all?
No, it was, and I can't cite to the record, but I know from personal knowledge it was.
That had nothing to do with,
Yeah.
with anything.
How many years will he do?
Okay.
That was the extent of it. And she recommended a number, and I said I could agree to that. I would like to talk on issue 2 on the invited error and the failure to give the second degree murder. The problem I have with the invited error is I have to admit it's error, and I don't believe it was error to not give second degree murder.
Well, you had circumstances clearly pointing to a premeditated murder, but no one really knows what happened out there in that road when Lane shot Farrell, right? So, I mean, it clearly was an intentional act, but wasn't there evidence to support a second-degree murder because of the uncertainty?
Well, and I guess what this gets to is the dissent in the Haberlin. I think that's where Justice Rosen says we're kind of getting into this theoretical. And I think this court has an opportunity with this case to clarify. As I read Haberlin, the evidence in that case of second degree was threadbare. But if you look at it in a certain light, there was maybe some evidence. But in this particular case, in the Soto case, there's no evidence of anything but premeditated murder. Now, they refer to, Lane gave 11 different versions, but there's no proffer of what those versions are. I mean, so it is all
why do we
theoretical.
care about Lane's version? This is Soto on trial, and don't we have to find that Soto aided and abetted with a premeditated intent that the gun be used to kill? I mean, it doesn't matter if Lane, it premeditated the murder, but Soto was believed when he says, I didn't think he was doing it. I thought he was running his mouth off, and, you know, I had no intention for this person to get killed with this gun. If they believed that, then even if Lane premeditated, Soto didn't premeditate. Would you agree with that?
No, I wouldn't. And here's why. The defense argument is that Soto didn't have, I mean, the defendant's argument wasn't that Soto didn't have premeditation, but rather that he didn't have the intent to kill. That I gave him the gun, but I didn't think he was going to use it. That's not dealing with premeditation. This is a unique case because if Soto gave the gun with the intent to kill, then the premeditation's built in. I mean, you can't give someone a gun and say, you're going to go kill someone with it and not have premeditation. So the issue here was, did he really have the intent to kill? Because if he had the intent to kill, the premeditation's built in. And that's why I'm saying that this court has an opportunity to give us some guidance on the Haberlin case by saying, look, if there's threadbare evidence, then you need to give the instruction of lessers. But if it's all theoretical, like in this case, then you don't. Because we're struggling with what to make of the Haberlin case, whether there's a factual component in the lesser included. And I really think this court has an opportunity to, and I don't want to...
Let's go back to the facts then. Soto would respond to text with a WC.
I have no idea what that means.
Thank you.
Yeah, I don't know. I don't know. I don't even know if I suggested to the jury
That's
what
what
it
it
meant.
Probably some people in the audience who might
It's-
tell us.
Yeah, I don't know. I have no idea what it meant. But it was clear that what Lane was wanting. I want him under. I need him under. Let me do it, boss. So I would suggest to this court that if the court, obviously I think invited error, we don't just rely on State versus Angelo where the defense attorney said, no, don't give us this. But there is a Supreme or a Court of Appeals case of Hernandez where it's factually identical. The judge said, do you want this instruction? Do you see any reason for this instruction? And they say no. So Hernandez on the Court of Appeals is identical to this, and they did find invited error. But I would ask the court to find that there is no error because it's all theoretical evidence, and there has to be at least threadbare evidence before the court is required to give an instruction. As far as
Well, on that point, I mean, during Soto's comments to the police and others, and to other individuals, he indicated he didn't think he was going to do it. He didn't think that Lane had the willpower or the temperament or
the
whatever.
guts, I think he
The
said.
guts, right, okay.
But that goes towards the intent to kill,
Mm-hmm.
not towards premeditation. I mean, if the jury said, well, we hear what you're saying, but, he sent you a message, he told you wanted to do, you gave him the gun, you told him to take him off the property. I mean, he certainly showed violence towards Mr. Farrell by striking him. And if the jury says, yeah, we think you had the intent to kill, the premeditation is there.
Well, your argument is if the jury believed his statement that he didn't think he was going to use the gun to kill, then he was not guilty. It wasn't that he was guilty of second degree, it was that he was not guilty
Exactly,
of
yeah.
aiding and abetting a murder. That's your argument.
Yes,
That's
yeah.
where
It really is one of, not to interrupt, but it really was one of those all or nothing. If he didn't, if he gave him the gun and didn't think he would use it to kill, then he's not guilty. And that's what the defense argument was. And I think the defense said that Mr. Seaton said that at the very beginning, that was the argument. As far as the abuse of discretion argument, the trial court's decision to deny the new trial was not an unreasonable one. And Justice, you said, you brought us back to the point that it is an abuse of discretion standard. And there's certainly, I think, what occurred during that noon break is simply not material. And I would like to, I think to be material, it really needs to have an effect on the trial. And nothing that occurred really had anything to do with the trial. So I don't believe that it amounts to any sort of due process violation. And when you talk about due process, does it shock the mind? Is it? And the defense attorney admitted, I don't even think the defense. He says, I don't even think the state thought about this. And that's just not the type of thing that shocks the mind and would require a due process violation. In sum, Mr. Soto had a fair trial. The jury was presented with overwhelming evidence of his guilt, and a large part of that was based on his own statement. We would ask that you uphold the jury's verdict if there's no other questions.
Any more questions? Thank you, counsel.
Thank you.
I would waive rebuttal.
You would agree that if there was no plea agreement, that your first issue doesn't exist, wouldn't you?
Was no plea agreement between Lane and the state?
Yeah.
Okay, sure, yes.
Yeah, well, he's just said all they did was this is just chatter between the lawyers, and he doesn't have it, and the defendant hasn't agreed to the number. So that's not a plea agreement, and we certainly have a gazillion cases up here where the defendant changes their minds even after they've shook hands.
Yeah, I just have to refer you back to the hearing on the motion for new trial where the defense proffered, and I don't think the state was quite so casual at that hearing about whether there had been agreement or not. I think they pretty much said there had been an agreement. I think the record would speak for itself on that. The prosecutor didn't dispute the defense proffer on that. So I would just rely on the record.
Any more questions?
Yes. Given these facts, explain how the jury could have convicted of second degree.
Well, okay, so I guess under the state's theory is that Lane is thinking about killing this gentleman and he wants Soto to give him the gun. And Soto is like, I gave him the gun, but I didn't really think he was going to do it. So the theory here is that he gives him the gun and thinking Lane at some point, theoretically in second degree, that Lane at some point may decide to kill him. That this is still up in the air. So he's facilitating the crime by giving him the gun. And then Lane at some point makes that decision. Something happens in the car. We don't know what happens in the car. Maybe there's an argument, maybe there's a dispute. At some point, instead of just threatening the guy, Lane decides to shoot him.
But isn't our case law that the aider and abettor has to have the intent to kill also?
Well, and again,
you can't have accidental aiding and abetting intentional murder.
Right, so he's trying to, I think a jury could interpret this evidence to say, I mean, from a strictly legal point of view, this is debatable. But from the instruction and the evidence, a jury could conclude he facilitated the crime, and at some point Lane made the intent to kill, and a jury could be swayed to go with the lesser, because Soto's culpability here is for giving the gun.
But how would the evidence support that? The jury, they can do whatever they want, the jury nullification, but how legally is where we're talking about now. How can legally the facts support a second degree?
Simply just because the detectives said that Lane had given so many different versions of what happened, that it's unknown what the circumstances around the killing. And
well,
Soto,
we don't care about the circumstances surrounding the killing so much as we care about what was Soto's state of mind. You said when you started that was their defense.
Right, so if Soto had said, if the evidence was, I'm giving you the gun, I know you're going to go kill him, right, that supports the premeditated intent to kill. Soto has a premeditated intent to kill, but in this case, there was uncertainty around it. So I'm giving you the gun, knowing that at some point you may or may not use it. Something may happen and you may intentionally kill him. But I'm not giving you the gun definitively with a premeditated intent. That would be the evidence.
Does it matter that there was a possibility that Lane might not kill him, as long as Soto provided the gun knowing that it could be used
Mhm.
to kill.
Does
Is
it matter?
that, I mean, is that all we need to know that second isn't a factor here? Because Soto didn't give it with the thought of, oh, I'll give this to you so you look tough. And when you're talking to him, he gave him with the intent that when you decide to kill him, you've got a gun to kill him.
But the gun could be used for other ways too. The gun could have been used to threaten him, just to be muscle.
But there's no evidence of that. That
Right,
was
right.
even contemplated.
Right, yes.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.